Hello everyone. Today we bring to you a video on drafting terms for NFT platforms. Now, NFTs are the buzzword for today. Everybody is talking about non-fungible tokens. But do you know how the terms of use for these NFT platforms are drafted? So we are going to talk about what is a NFT and what are the key legal considerations one needs to keep in mind while drafting terms for NFT platforms. What is a NFT? Now, you've heard of non-fungible token. What is a non-fungible token? It is a token that cannot be divided into two. It is a unique token. Fungible means to divide into two. Non-fungible means something that cannot be divided. So a non-fungible token in essence means a unique token that cannot be broken into part by part. Now it's a digital asset. An NFT is a digital asset. For example, it could be a digital art or a digital form of any other collectible, for example, baseball cards, Thor's hammer, etc. Now, typically NFTs are bought and sold in cryptocurrencies. Now, think of it as something that gets laminated. Now, for example, if you buy a NFT from an NFT platform, for example, which is the Thor's hammer. Now you get this hammer in a digital form and it is laminated. And this lamination forms the certificate of authentication for this Thor's hammer. And this lamination that distinguishes your asset from someone else's asset is the NFT that you get in the Thor's hammer. So someone else may also have a Thor's hammer and they would have a different lamination over it that would be their NFT. And this would be your NFT. So it's just a digital asset packaged into unique forms, which constitutes a NFT. Now, what is the NFT platform? So if you noticed, the heading of the video says terms of use for drafting for NFT platform. Now, not for NFT, but an NFT platform. Now think of Amazon. There are different sellers and buyers on Amazon selling and buying different kinds of goods, right? An NFT platform is the Amazon for NFTs, where there would be different sellers and buyers who would be there and they would be selling their NFTs on that particular platform. Now, an NFT platform does not provide the wallet in which your cryptocurrencies are stored. It is not directly selling the NFTs to you. It is just providing a platform where people who want to sell NFTs and those who want to buy NFTs come together and engage in such transactions. Now, it's a mere facilitator of NFT transactions. It does not have any control over seller and purchaser transactions, and sellers can have their own purchase terms, which would be different from the terms of use for an NFT platform. Now, it's important to understand what an NFT platform is and how it is different from a direct seller of NFTs. Because when you are drafting terms and conditions for an NFT platform, it's not that you are drafting terms and conditions between a seller and a buyer. You are drafting terms and conditions between a platform that provides the services of selling and buying and the user who accesses such platform. So that is why the context of the business needs to be understood here. Now, how do you typically use the NFT platform? You'd have a blockchain address. You'll have a wallet that is compatible with the blockchain which the platform uses. And the security of this wallet is the responsibility of the user and not the NFT platform. So when you are drafting terms and conditions of the platform, you need to have these things in writing. So you say how the user needs to have a wallet which is compatible with the blockchain being used. So if tomorrow some user comes and puts a claim saying, I did have a wallet and it did not work, and now you are liable for the same, this term and condition is going to help you avoid such claims. Similarly, security of the wallet has to be the responsibility of the user. There should not be any unauthorized disclosure of the password, the username, etc. If there is any suspicious activity in the wallet, the NFT platform should have the right to suspend the usage of that wallet or the account of that particular user. So these things need to be captured in the terms and conditions of a NFT platform. Now, representations and warranty. This is extremely important because as a platform who is not directly engaging in buying and selling of NFTs, you need to have all the representations and warranties upfront made by the user so that tomorrow you are not the one who's getting engaged in any lawsuit or in any claim that comes against the user just because you provided a platform for the user to either buy or sell the NFTs. First is compliance with applicable laws. Now, especially anti-money laundering laws. So the user should not money launder any illegal money or any illegal proceeds into the wallet, and then they try to uh, purchase or sell NFTs through that. Then engaging in such transactions is not prohibited in the user's jurisdiction. So for example, if a country has prohibited buying and selling of NFTs, and the user is using your platform to buy and sell these NFTs, and tomorrow you get into legal trouble for that. So that should not be the case, and therefore this representation and warranty should also be there. The user is saying that yes, my jurisdiction allows me to engage in such transaction, and it does not fall under an illegal transaction based on the jurisdiction I am located in. Now, the user has not allowed any third party to use their wallet for the purpose of the transactions. As we said earlier, the wallet needs to be safe and secure. The user's account needs to be safe and secure. So no unauthorized person or any third party is coming and using the user's account or user's wallet to engage in NFT transactions. So these are some of the representations and warranties that need to be there in the terms of use. There are many more depending upon the context of the services. Now, disclaimer is the essence of the terms and conditions of an NFT platform. The first thing you need to tell the user is that they are engaging in this transaction out of their own risk and also willingly and with an informed consent. So they know the risks associated and still they are going ahead and they are engaging in such transaction. If anything goes wrong, the NFT platform is not liable for the same. And that needs to be put in as explicit words as possible. Now, information disclaimer stating that the NFT value is volatile. It is based on underlying assets. It can either rise too high, it can either drop too low. So any risk undertaken is solely the user's liability. The user is aware that these kinds of volatilities may occur and the user may incur loss. So therefore, this needs to be again put very clearly in the terms and conditions. Another thing which the NFT platform should do is that it should clearly state that by the virtue of creating this platform and providing this platform, it's not guaranteeing any successes with the NFTs or any monetary gains. And it's all the user's liability, user's responsibility, and the user is engaging in this transaction out of their own volition. Also, the NFT platform is not responsible if any change in law happens in the future that renders an NFT transaction illegal. It is the user's responsibility to keep themselves informed. Now, ownership is one of the most contentious issues when it comes to drafting terms for an NFT platform. This also becomes important when drafting purchase and sale contract between a direct NFT seller and a direct NFT buyer. Because so firstly, the platform, the website that is there, the information, the logos, the images, etc. are all the property of the NFT platform and not the buyers or the seller. The NFT per se is the property of the NFT purchaser. So if you buy a Thor's hammer, the laminated version of the Thor's hammer is your property. You are the NFT owner. But the Thor's hammer inside may not be your property. That would be the property of the person who mints the NFT or who owns the NFT. It could be the seller or any third party. So for example, if someone tweets, for example, the first tweet was created into an NFT. Now, the NFT of that tweet was the property of the purchaser of that NFT. But that tweet per se would still be the property of the person who wrote that tweet. So that's the difference. Ownership in NFT does not give you IP rights in the NFT content which is being created into an NFT. So if tomorrow a painting gets converted into digital art, into NFT, you own rights to that NFT in the digital art, but not to the painting itself. So that is something which needs to be clearly spelled out in terms of use of NFT platforms, because and users should know what they are getting into, so that tomorrow they do not bring a claim against you and say that I was misled. So these are some of the legal considerations that you need to keep in mind while drafting terms of use for an NFT platform. There are many more that need to be kept in mind, which you will understand and learn as you understand the context of the services provided. I hope this video was of help to you. In the event you require any further clarifications or information, please do not hesitate to contact me on my LinkedIn or visit our website. The URL is given here. Thank you. Have a nice day.